The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Good afternoon. We have 5 cases that will be submitted. They are Maxine Veatch versus City of Waverly and Jason Leonard. Second case is Luna State or Savings Bank versus Pro Build Holders, Inc. and United Building Centers. The third case is Alta Vista Properties versus Mauer Vision Center. Fourth case is State of Iowa versus Kevin Ambrose. And the final case this afternoon is In Re the Interests of J.C. The last 2 cases are submitted without argument at this time, and we'll now hear the arguments in the Veatch case. Ms. Hansen.
May it please the court. Counsel, good afternoon. We're here after a very long journey in a case that began in September of 2006 with the arrest of Maxine Veatch by Jason Leonard, an officer of the Waverly Police Department. That arrest, which spawned a federal lawsuit in the Iowa District Court in Cedar Rapids, Iowa, on a multitude of claims, including 42 U.S.C. 1983 and several state court claims, including the one that is before you today for false imprisonment, false arrest, included a second set of defendants, which was Bartles Nursing Home. What remains today to be decided by this court is the false imprisonment case. But as background, it's important to understand the process that occurred before today. And that is that the federal district court decided the 1983 case involving probable cause for the arrest under a constitutional standard and dismissed the case against Jason Leonard and the city. That case was appealed to the 8th Circuit Court of Appeals, and that was argued by opposing counsel and I, and was upheld by the 8th Circuit Court of Appeals. They finding that there was constitutional probable cause to have arrested Maxine Veatch, finding that there was no problem with it being an arrest under a misdemeanor rather than a felony. The court at the district court level in Iowa dismissed the state court claims, having ruled on the federal claim, and advised counsel that if they wished to file the remaining claims in state court, they could, which they did. For various and sundry reasons, the Bartles claim eventually was separated from our claim, and this case proceeded to...
Counsel, let's move to the issue preclusion question.
All right.
Why should we conclude that the federal court's determination that there was probable cause for purposes of the Fourth Amendment it resolves the same issue that is before the court in this case? Aren't they different questions?
Well, I think you have to look at your own Children case, Children versus Burton case. In that case, the Iowa Supreme Court, I don't believe any of you were on this court at that time, and I may be mistaken, but I think that was a long time ago. In that case, this court said that the probable cause standard for a civil lawsuit was less than the probable cause standard under a constitutional standard. And so reasoning, as we do with criminal cases, that if you think about the old O.J. Simpson case, if O.J. Simpson had been convicted in the federal case, then he wouldn't, the the parties would not have had to prove those elements in the civil case. In this case, he was acquitted, so they had to prove their case in a civil case. But the burden of proof in a civil case is less than the burden of proof, and that is.
I understand what you're saying, but I mean, following up on Justice Heck's question, isn't it a separate question whether 804.7's requirements have been met as opposed to whether the Fourth Amendment's requirements have been met? I mean, the statute is different from the Fourth Amendment and has different provisions, right?
Well, first of all, I think that you have to consider the fact that 804.7 doesn't create an independent cause of action, doesn't create a civil cause of action, that the civil cause of action is a tort-type claim.
Right, it's a tort claim of false arrest.
Correct.
Based on the allegation that the defendants didn't arrest without legal authority to do so. One source of legal authority would be 804.7. If they're not following 804.7, don't they have a problem?
Well, one could argue that only if the requirements for the arrest doesn't include probable cause, and that probable cause is not a lesser standard than the constitutional probable cause. In other words, the constitutional probable cause that it's already been litigated, that boat has passed. I mean, it's gone. That is fully and fairly litigated. That's been determined. We have probable cause. And we have probable cause from a constitutional standard. So when you get into the second element of false arrest, which is unlawfulness of the detention or restraint, that probable cause standard, we think, meets that element with or without 807.2.
Let me tell you where I'm at least, and I'm just speaking for me. Assuming we don't have issue preclusion, the question in my mind is, can you salvage the arrest under 804.7 on the grounds that there was probable cause to commit dependent adult abuse, even though that's not what she was charged with? And that's the question I'd like you to address.
Well, yes. And I agree that that is a strong argument in this case, because the facts are in this case. We have preserved that all the way through. We argued it at the state court level. We argued it in front of the Court of Appeals, and we've argued it here in the briefings at this court level too. And that because she had that durable power of attorney for healthcare decisions, she was making all of those decisions for her mother, that she met those requirements and could have been charged with that crime. The other thing is, and we have not made this argument before, and perhaps it's not appropriate, but she could have been charged with assault with injury. And what you do and the Court of Appeals did by dismissing that out of hand, is that what you impose on the officers then is always citing a criminal defendant with the highest possible charge that they could find.
Okay.
That's particularly in light of when they have a lesser charge, which would be a simple misdemeanor.
At least a felony rather than a misdemeanor, so that you avoid this problem.
That's correct. That's correct.
Well, counsel, I would like you to help me with clarifying precisely what the record shows with respect to whether dependent abuse was actually within the contemplation of anybody at the time of the arrest. And it's unclear to me after reading the record, and so I'm hoping you'll help me with it. There's one interpretation of the testimony was that there was a phone conversation between the nursing home staff and the Department of Human Services, specifically with respect to the subject of dependent abuse. And there's some indication that Officer Leonard was on the phone at the time that conversation occurred. But is that the way you read it, or not?
I'm trying to remember because I reviewed the appendix in preparation for today too, and I honestly, I can't recall without misleading you. It's been so long.
Well, is that an important factual question? That is to say, is there some temporal requirement that at or about the time the charge was filed, an indictable offense must have been within the range of potential crimes considered by the charging officer in order to get support under 80473?
I don't believe that that's what your case suggests, and I think there's only one case in the record, and if you give me just a moment to look at my notes to remember the case, there's one case that's been cited in this record that talks about a charging officer who could have cited to something other than a simple misdemeanor, and that the officer didn't cite to that, and the case then goes on to say that it doesn't matter whether the officer had contemplated it or not. It's simply whether the facts would have supported such a charge. Because officers are often called upon to make these decisions based on the information that they have at the time, based on their best professional judgment. This goes into also discretionary, the officer exercising his discretion. What is he thinking about at the time? What is he thinking about in terms of the facts and circumstances of this case? And there are lesser included crimes if you look at the misdemeanor, and I may be wrong, but it's 701 and 702. And I think under 2 there are various subcomponents about assault with injury, with intent. All of those would be technically assaults, but various levels of assault. He simply selected the simplest assault there. And in terms of what was in his mind at the time, I don't recall. I know that simultaneously, the nursing home was simultaneous was making the report to the police. They were reporting to DHS.
Okay. On another point, I'd like to just briefly cover the extent to which, if at all, 80472 might be support for a statutory basis for the warrantless arrest in this case. And I'd like you to comment on what your construction or interpretation of the phrase offense has in fact been committed.
All right.
Go ahead.
All right. If you look at the Young case, which the Court of Appeals relied on, if you look at the Young case, you see it only has 2 subparts. The first is in the presence, and the second is in an indictable offense. When you look at 7 and 804, you have 3 components. You have 2 that are identical to the one involving a private citizen, and then we have an extra step. And why would the legislature give police officers an extra step? And when I look at that extra step and I see the term reasonable, and I see those 2 components there with the word and, to me what the legislature was doing was giving the officers the ability to use probable cause on both components of that number 2. That if the officer has reasonable belief or probable cause to believe that a crime has been committed and that the person has committed the crime, then the officer can arrest without a warrant. And And that's what we believe is appropriate for the interpretation of that section. That the officer, when gathering the facts, and the Court of Appeals, at the very end of their decision, seemed to be saying the same thing, and simply said that...
Why wouldn't, I mean, it seems to me if that were the purpose behind 2, the simpler way to draft that would have just been to have subsection 3 without the indictable limitation in it, if the intent was as you just suggested.
Well, but if you go back to the common law, if the legislature was intending to reflect the common law, they wouldn't have even put 2 in there. Because under the common law, the old law, then they had to have it in the presence of the police officer, or it had to be an indictable offense. But they added 2. They added 2 so that a police officer, if he had reasonable belief or probable cause to believe that a crime had been committed and that this person had committed the crime, that they could arrest.
Doesn't it seem like kind of a strange way to word it? It says where a public offense has in fact been committed, and you're saying it means where the police officer has reasonable grounds to believe a public offense has been committed. Those are 2 different things, right?
Unfortunately, the legislature isn't here for us to cross-examine them, and
Fortunately, actually, I think,
well,
for all concerned.
And this court is left on many occasions to have to try to determine what...
Let me ask you another question. Let's say that it isn't an element in order to have a valid arrest that the public offense actually has to have been committed. Is the fact that she was acquitted determinative, or do you get to go in and relitigate that because now it's a different burden of proof?
The fact that a criminal defendant is acquitted should never be determinative in a civil action for false arrest, provided that there's probable cause.
Well, so if we're right, or I'm not saying we're taking a position, but if it turns out that you have to show that a public offense has been committed to have a valid arrest, that's still an open issue. Is that your view?
I'm sorry. Would you please say that again? I'm not sure
what
that
I'm
we've
saying is
communicated.
you still would get to litigate that issue. The fact that she was acquitted of the public offense is not determinative for purposes of whether there was a false arrest under 804.7, right?
Whether or not the officer believed that a public offense was committed would need to be litigated.
But let's say we end up not reading the statute that way, and we read the statute as saying that the public offense actually has to have been committed. Do you get to relitigate that issue? Because although she was acquitted, the state had to show beyond a reasonable doubt that she was guilty.
Yes, because of the different standards in civil and criminal matters. All right. Getting back to your original question about the dependent adult abuse and the report, what I can tell you is that simultaneously with the report to the police department, the nursing home made a report to DHS that the investigations occurred in a parallel track. The record, I believe, shows that the hearing on the criminal matter and the hearing on the DHS matter, which the DHS matter was in 2 phases. The first phase of the DHS matter, Ms. Veatch was found to have committed dependent adult abuse. And in the second phase of the DHS matter, which I'm not familiar with that process, she was exonerated on that charge in the second phase of the DHS matter. And so I can tell you it was also along the same track. Also should be noted that the initial report for this investigation was taken by another officer, Officer Lubers, who filed a report, which report is a part of this record and found in the appendix and includes facts and details which would have been relied upon by Officer Leonard as he processed this report. And to the extent that there is case law that says that the officer is entitled to rely upon his colleagues' reports and findings in terms of determining whether or not probable cause exists, we would say that that also supports a finding that he had probable cause to believe that a crime had been committed and that Ms. Veatch had committed that crime. Thank you.
Thank you as well, Counsel. Mr. Hines.
Good afternoon, Justices, Counsel. My name is John Hines, and I'm an attorney from Waterloo with the Dutton, Braun, Stock, and Hellman Law Firm. And it's my privilege to be here this afternoon representing Maxine Veatch, financial planner from Cedar Falls. The legislature has made pretty clear its intention to maintain the distinction between what's required to effectuate an arrest for a simple misdemeanor offense versus what's required to effectuate an arrest for a more serious or an indictable offense. And they've expressed that intention in the code section 804.7, which, as Ms. Hansen has indicated, has been on the book since 1851, I believe. Now, I'm not a big fan.
Counsel, we've of course had some conversation about just how this arrest matches up with 8047 and the 3 subparagraphs there. But I'd like to direct your attention to the children case and have a conversation about the impact of that case on our decision here. As I read children, it looks like that case stands for the proposition that even if Officer Leonard didn't have a proper basis under 8047 to arrest, as long as he acted in good faith, the city and the officer are off the hook. And so that's one thing I'd like to have you address, that affirmative defense as we describe it in children. And then also, before you get away from children, I'd like to have you talk about the language in children which suggests the standard for reasonable cause for arrest in a false imprisonment or false arrest case is lower than the constitutional standard for probable cause. So would you focus on that for me, please?
I will, to the best of my ability, and I'd like to tie it in, if I can, with some of the other questions that were raised, because first off, a question was asked, what is meant by has in fact been committed under that code section? And another decision that was asked was, if we have a not guilty verdict, do we relitigate the occurrence in the civil action? Okay. I think it kind of all ties in with children, because in the way I see this case going is if it's sent back down, Officer Leonard will be able to rely on the defense of good faith. And I think that's separate from the statute. And I think that's probably where the lessened burden of proof, we could look at this and say that if the verdict comes back not guilty, then we don't relitigate that issue. Rather, we look at what the officer, what information he had available to him, what he did, and decide whether the good faith immunity applies to bar recovery. Does that make sense?
Sure, and I guess specifically, I'm hoping that you'll address whether there's substantial evidence in the record suggesting that the officer didn't act in good faith. That is to say, why shouldn't that issue be dispositive of this appeal?
Okay, I think that this whole case could be presented as Exhibit 1 in favor of why 804.7 represents good policy. And I'm not a fan of the legislatures either. And sometimes they craft statutes that don't seem to be in touch with reality. Maybe this one makes so much sense because they haven't messed with it since 1851. But this strikes a proper balance between individual liberties in avoiding an unnecessary arrest and the societal concerns with public safety and legitimate law enforcement. And the more serious the crime, the less that's required to make the arrest. So when we're talking about a simple misdemeanor, in the presence is all that's required. If we're going to go and we're going to rely on information other than what the officer's senses are, then we require more. So as far as this record goes, there was no reason for a warrantless arrest in this case. The arrest was made 2 days after the incident occurred. There was no reason to throw this middle-aged professional woman in jail who'd never been in trouble before and keep her overnight. There was this officer, by his own admission, acknowledged that, and this is not a patrol officer. This is the lead investigator who had 10 years experience for the Waverly Police Department. He acknowledged that he abandoned his standard operating procedure and made this arrest without interviewing the victim. He'd never done that before. Never done that before. He didn't.
Well, he did ask the nursing home staff for that opportunity, right? And he simply was persuaded by them that wouldn't be a good idea because the 92-year-old elderly Mrs. Bell would be intimidated or scared of retaliation if Mrs. Veatch found out about this problem and would be upset by the meeting with the officer. I mean, so in terms of good faith, is his mere deviation from his ordinary procedure of speaking with both sides, so to speak, and the victim in particular, is that substantial evidence of bad faith in this case, or something less than good faith?
Well, that's an accurate recitation of the record. I'll say that. Maybe the only additional thing is that they did interview Mrs. Bell, the staff, people who were comfortable with her, tape recorded it, and provided it to the deputy on October 16th. The arrest was on September 29th. The victim, he could have at least made a phone call to the victim. He could have at least reviewed the victim's statement. He could have at least made some attempt to find out from somebody that had firsthand knowledge what happened. The other thing that he did was he relied totally on third-party reports. And these just weren't any third parties. These were third parties who were extremely biased and had an axe to grind against Mrs. Veatch and acknowledged to the investigating officer that they were trying to ban this woman from their facility because she was making too many complaints to the staff there about the inferior care that was being provided her mother. In addition to that, the arresting officer spent 2 hours, 1 to 2 hours, visiting with that staff, hearing about all this garbage, collecting documents that backed it up. Then when he calls Mrs. Veatch and asks her to come in to give an interview, once she finds out what this is about, she asks if she can have an attorney present during the interview. And he, rather than making arrangements to find out what her version is, he walks into the other room and comes back with a complaint form that he pretty much already had completed and throws her in jail. That's disturbing.
Yeah, Mr. Hines, let me ask you this if I could. Going back to 804.73, the reasonable ground for believing an indictable public offense has been committed. Now, don't we evaluate typically reasonable ground on an objective basis? We don't require the peace officer to have that charge subjectively in his or her head at the time. And if that's the case, why isn't that a defense? If there was reasonable ground for believing, I'm not saying this was good police work, but if there was reasonable ground for believing that dependent adult abuse had been committed.
Well, we have gone down that road in other areas. And many of them involve factual situations which can be clearly distinguished, and I think in this case need to be. Many of those cases, I believe, involve a patrol officer who makes an observation of what he thinks is a particular traffic offense, and it ends up to be something different. Okay, a stop of an automobile. Not quite as infringing as throwing somebody in jail. I think the other cases where that's done is where the officer, and I'm thinking maybe of the lawyer case, which was a federal case, was present and observed the misconduct and maybe made a mistake or the wrong call on what they charged them with, but they were personally aware of all the facts that were going on. So that's a little bit different than this. You know, the Court of Appeals said Monday morning quarterbacking, which was a pretty good term. And if we're not gonna, if we're gonna say a not guilty verdict doesn't equate with this offense not occurring, if we can't do that, I'm not so sure we should recreate the situation for the officer, at least where there's no indication that that was seriously under consideration. And this, let's just look at the policy thing of all this. Don't we want our law enforcement officers, before they make an arrest, not issue a citation or a summons to appear, but an arrest, you know, to sit down and really think it through, and think through 804.7 and say, okay, what am I doing here?
Well, let me ask
does
you
this
this.
fit?
What's your definition of, under 804.72, that a public offense has in fact been committed? How do you define that?
I don't know, other than it's something more than reasonable grounds and reasonable grounds.
Well, one example I thought of, and there may be others, but it might be a situation where police are called to a home, there's a body with 34 bullet wounds, and a quick post-mortem is done, and the autopsy report shows without any question that the victim died of gunshot wounds, and there's no evidence of suicide. I mean, that might be a circumstance where clearly we can say a crime was committed and there's not much question about it. There are lots of other factual scenarios where it's maybe much less certain about whether a crime has in fact been committed, but we could spin all those out and draw this large continuum, I'm sure. But are there others that you've thought of?
Not really. The best way
There's something like a criminal mischief where there's a broken window and you know that a crime's been committed because somebody perhaps broke the window, and then you talk to somebody who saw somebody else throw a rock or a brick through the window. But are these factual determinations? You know, we're here on a summary judgment, so we have to have no genuine issue of material fact and as a matter of law, or do we make that determination as a matter of law that this is or isn't a good arrest at this point?
I don't think you can under the facts. I just don't think that the element that wasn't addressed in the federal court that we've been discussing so much hasn't really been developed. And that's the other thing also about the charging and did he have grounds to do an indictable offense? The record that hasn't been developed either. I mean, that's been argued, but as far as the record goes, it's cloudy at best. I don't think the officer was on the phone to DHS, but I could be wrong. I think that was the facility. He may have been in the room though. So, but no, that's why I almost think it.
Is the record clear what the subject of the conversation was during that phone call? Were they simply asking DHS whether there was a basis for a protective order or for excluding Ms. Veatch from the premises, or were they in fact talking about, does this rise to the level of a criminal violation? Do you know?
My hunch, and I don't know for certain, was that they were discussing facility issues rather than a
Well,
criminal
aren't they
charge.
mandatory reporters? Isn't this one of those mandatory reporter things that if they feel that one of their residents has been assaulted, abused, I mean, they're required to contact DHS, aren't they?
You're right, Justice, and in fact they did, and that may have been the phone call. They definitely did, because there was a dependent adult abuse finding that was issued that we ended up appealing and reversing, and they were the reporting party. I just think, just in closing, that that we should expect our officers to take a close look at 804.7, and that maybe that hasn't been stressed enough, since this officer didn't even realize what he was able to do under the law, and acknowledge that. Thank you very much.
Thank you as well, Counsel. Rebuttal, Ms. Hansen?
And I guess I could start it off a little bit. The same question I asked Mr. Hines a little bit, Ms. Hansen. Is this really an appropriate subject for a summary judgment when we seem to have real genuine issues of material facts about whether either 2 or 3, subsections 2 or 3 really apply to this? And isn't it better left to a jury to make those determinations?
We believe that it's not. We believe that the ship has left the dock, and that argument, if it was to be made, had to be made in the federal district court on the probable cause finding in terms of the arrest. That the probable cause standard that this court adopted in Children is that the probable cause necessary to establish false imprisonment, false arrest, is a lesser probable cause than the constitutional probable cause.
So the primary argument is issue preclusion from your standpoint?
It is on that particular point. That applies both to whether the crime has been committed and or whether or not this person has committed the crime. And in response to your earlier question, while I was waiting for Mr. Hines to complete his argument, in the appendix at page 332 on, there is a record of the formal dependent adult evaluation and assessment, which is dated September 29th, 2006, and on 333, it suggests that the investigator began their work on 9/29/2006, which I believe is the day after Officer Leonard was at the home the first time. So I don't know that really lends any support one way or the other to your earlier question, but I wanted to point out.
Was that the day she was arrested?
I believe she was arrested on the 28th. I think we have to be cautious about not being caught up in the minutia of this, because there's a lot of moving parts here. We have the moving parts of probable cause from a constitutional standard. We have the elements of false imprisonment, which are only 2. And we have this unique situation in that we have a court other than our courts having found probable cause. But when you superimpose upon that the children's standard, unless this court intends to modify that in some way, we are left with the determination that probable cause in.
But does Childress really apply in this case? Because they came up with this good faith defense based upon the burden on the plaintiff to show it was reasonably probable that a crime has been committed. This is a crime is in fact been committed. So I don't know if the good faith defense, as I read Childress or Burton, however you want to call it, came out of subpart 3, but not out of subpart 2. And I'm not so sure it applies to subpart 2, because when they came up with this good faith defense, they talked about, having a reasonable belief a crime was permitted means you have a good faith that it was reasonably committed. But this doesn't, if we adopt a position that doesn't apply to subpart 2, where does it leave you on the good faith?
Well, if you come up with it not applying to subpart 2, then there isn't any scenario where an officer can be assured that he can ever use subpart 2. And
For example, someone goes shoplifts, and the store owner says, I had this bag of candy on the counter, and it is gone. And then you look at a videotape, and the videotape shows that Justice Apple walked out with the candy. You're a sweet tooth there. So does that mean, there was in fact a crime was committed, that someone walked out with the candy without paying for it, and 2, there's a reasonable belief that Justice Apple did it because the videotape showed he did. There's all kinds of things you could talk about that would fit under 2.
And isn't that what the 8th Circuit Court of Appeals did, and isn't that what we have here?
But 804.72 is not the same as the Fourth Amendment. But here's where I'm, if I could just ask one more question, Your Honor, Chief. Under 804.73, the Court of Appeals says, we believe the officer must have reasonable grounds for believing the offense has been committed, and these reasonable grounds and the officer's belief should exist at the time of the arrest. Do you agree with that about the officer's belief?
Of course. And the same is true under 2. The officer has reasonable grounds to believe that the offense has been committed.
Does he subjectively have to believe that that particular offense was committed, the dependent adult abuse? Does that have to have been in his mind?
No, I don't think that the officer, I think as long as there is an indictable defense available to him, that the officer does not have to charge that indictable offense. Thank you.
The Veatch case is submitted, and we'll now hear the arguments in the Luna Savings Bank case.